Today, the U.S. Supreme Court hearing oral arguments concerning the legality of Idaho's near total ban on abortions, including in medical emergency situations. The justices are being asked to determine whether Idaho's law conflicts with federal law aimed at ensuring certain standards for emergency medical care for patients, including pregnant women. The Biden administration sued, claiming Idaho's law does conflict. Idaho's 2020 law, called the Defense of Life Act, went into effect in 2022 when the Supreme Court struck down Roe v. Wade. It calls for anyone who performs an abortion to be subject to criminal penalties, including up to 5 years in jail and the forfeiture of their professional licenses. There is an exception for abortions to protect the mother's life. A federal law enacted in 1986 requires that patients receive appropriate emergency room care. The Biden administration argues that care should include abortions in certain situations. The law applies to any hospital that receives federal funding under the Medicare program. The suit claims the Idaho law is too narrow and only allows for an abortion to save a woman's life, but not merely to avoid grave harm to health, and that the conflict can put doctors in a difficult position, having to decide which law to follow.
We no longer have this protection, and it has been a distinct change with my colleagues and the patients that we serve in our communities in these last 4 months. It is untenable for physicians to continue to practice medicine this way, and we will continue to see that drain of excellent healthcare providers from our state, despite that what they want most to be able to do is take care of their patients and keep them safe.
Meanwhile, right here in Georgia, abortions are legal up until a heartbeat is detected. That's usually around 6 weeks gestation. Abortions are now banned or heavily restricted in 18 states.